I apologize for you. Well, then you are the first, then, because Thomas is not possible. Gonzalo. Thank you very much. Thank you for coming, for all. Of all, this is the second day and the final session of this workshop, of this seminar with the title "The Separation Thesis of Law and Morals." Very old question, archaeological philosophy, and we have two separated sessions, or discussion. The first would be Professor Thomas. He's very immediate, but Thomas has problem with the voice, and it's not possible to speak now for all of us, and I apologize in his name for the reason and but
You have some presentation?
No presentation, but I need somewhere to plug this in.
thank you, Thomas.
That's also possible.
No?
Thank you.
Okay, so there is no kind of plugin that I can use.
And the second,
No.
For the battery of the
this
laptop.
is the first
Oh my God,
session
so that's
is Professor Yaya Bertol Gulges, the Turkey Bursa Uludat University. Sorry for my pronunciation, horrible pronunciation of Turkey language.
no, it's almost perfect. Thank you.
And the title of the presentation is "The Thesis of Legal Positivism, an Argument in Favor of the Separability Thesis." I am passing the floor to Yaya.
Thank you very much, Professor. I have a small technical issue before that. I need to just charge my laptop.
Do you have that out USB?
No.
And we can.
No, okay, then I can use my phone. I'll try to
Yeah?
use my phone. Yeah, I mean, that's
Okay.
less comfortable, but it's okay.
I'm so sorry.
No problem.
But
I mean,
it's not possible to connect the PowerPoint. There is a
I don't have a PowerPoint, so
yeah, that's okay.
I just need some notes, but
That's okay.
I'll manage. So
That's okay. Go.
thank you very much for your presentation. It's an honor to be here, but I'll just require a minute of your time to just open my notes. By any chance, can I use this computer? Is this connected to internet?
For all
If this is connected to internet, I can use this computer if that's okay.
Yeah, exactly.
Okay, then no problem.
Yeah. You pronounce that? Okay. You can. Yeah. What do you need?
Gmail, but another account, please. I need to log in.
Okay.
Varmış. Allah teşekkür ederim. Evet sanırım. Actually, there is one over there. I think that one is free. Ah. Teşekkür ederim.
This way works.
Yeah.
This way works.
Yeah, I think it does. Thank you.
Perfect.
Apologies again for the delay.
Thank you. Thank you.
So the title of my paper is The Thesis of Legal Positivism, an Argument in Favor of the Separability Thesis. The paper evaluates the three alleged theses of legal positivism, these being the separability thesis, the social fact thesis, and the sources thesis, which is basically the exclusive legal positivist version of the social fact thesis. Now, the final argument and the fundamental claim of the paper is that the separability thesis should be preferred over these other theses. And the argument rests upon something that I call a conceptual truth about normativity and legal norms. So let me just start with what this conceptual truth is. Now, I assume that it is almost tautological that where there is a norm of any kind, the addressees of that norm must have some kind of reason for action to comply with the norm. And in case we don't have such a reason for action, the entity that we're talking about cannot be a norm. The weight of the reason is insignificant, nor is it required that such reason for action must be conclusive or undefeated. And this is simply because even non-conclusive or defeated reasons for actions retain their characters as reasons and therefore their normative force. These reasons addressees must have might stem either from the content of the legal norm, for example, because the legal norm has a content that is morally valuable, or because complying with the legal norm will serve the well-being of the agent, or from another norm, for instance, from the fact that there is another norm which sanctions the violations against the legal norm in question, in which case the agent would have a prudential reason to comply with the norm. And lastly, following Matthew Kramer, I think that the only kinds of legal reasons that exist are either moral reasons or prudential reasons, and we don't have any other category. So based on this, what I call the conceptual truth about norms, I would like to proceed with an evaluation of the social fact and the sources thesis. So as you know, the social fact thesis is generally formulated as follows. The determination of the existence or the content of legal norms does not necessarily depend on evaluated criteria. In other words, a legal system is conceptually possible where all legal norms, the validity and the content of all legal norms are determined by reference to social facts and social facts alone. And the difference of the sources thesis is basically that it is not possible under the exclusive version that at any point in time, the validity or the content of any legal norm depends on evaluative criteria. So one version allows for the occasional consideration of evaluative considerations, but the exclusive version does not. Now, both theses concern evaluative criteria and not merely moral criteria. As John Gardner noted, his version of positivism, which is exclusive legal positivism, excludes prudential considerations as well as moral considerations. So this is also evident in the insistence of the both theses that the validity or the content of the norms either may be or must be determined solely based on social facts. As such, these theses appear to be epistemological in the sense that they concern the determination of the validity or the content of the norms, and they do not necessarily reject the fact that law might have some moral value necessarily due to the social facts that render it the law. In fact, Joseph Raz, an exclusive legal positivist, believes that it may be possible for the legal system to have moral value, necessary moral value, due to the things that, the social facts that make it the law. Now, based on these definitions and explanations, I think it's rather clear that the social fact and the sources thesis cannot accommodate our conceptual truth. Under that conceptual truth, I argued that the norm character of a legal enactment depends on whether addressees have at least some kind of reason to comply with it or not. Of course, there are other additional criteria, but this is conceptual criteria that should be indispensable for the norm character. But before drawing this conclusion, arriving at this final point, I think there are a few considerations that we must take into account, which could possibly establish the bridge between this conceptual truth and the social facts and the claim that law is only constituted upon social facts. First and foremost, requiring every legal norm to be sanctioned may be the bridge that we're looking for. Because if every single legal norm must comprise a sanction, this means that every single addressee will have a prudential reason to comply with the norm and to refrain from violating the norm. However, this option, as we all probably are aware, suffers from a few well-known criticisms pointed out by Hart and others, and I will not dwell on these here. More importantly, however, even if these criticisms are somehow refuted, a problem remains, and the problem is this. I believe that this route, like requiring every single legal norm to be sanctioned and therefore guaranteeing that the addressees will have at least some prudential reason to comply with the norm, is simply concealing the fact that what is under consideration is actually evaluative. Because this concept of sanction is an evaluative concept. It's usually defined as an evil to be imposed upon the violators of the norm. And the consideration of whether a certain norm includes this evil or not would be inevitably evaluative. Now, another possibility is a hybrid between the fact that legal systems must be efficacious and Jules Coleman's reasons to do as others do. This was Jules Coleman's idea was basically an effort to demonstrate that Hart's theory could actually explain genuine normativity. And legal positivist accounts almost always require that legal system must exhibit a certain level of efficacy. And efficacy is simply the rate of compliance by the addressees to the norms of the system. If this is combined with Coleman's idea that sometimes agents actually have reason to do as others do without taking into consideration why others are behaving in a certain way, one could perhaps claim that since legal systems are conceptually efficacious, and there is no way that a legal system is exhibiting a level of efficacy below a certain level, you could perhaps argue that this provides a reason for action for all addressees of that legal system. But I think this approach would suffer from two deficiencies, and two important deficiencies. The first is that unless we guarantee that people who behave in a certain way and who therefore contribute to the efficacy of a legal system are doing it for a reason, the other addressees who do not necessarily comply with the norms of the legal system would actually have no reason to comply with the same norms. And this would in turn mean that the pure factual concept of efficacy, which is rate of compliance, is not sufficient to establish that efficacy combined with Coleman's idea could guarantee that every single addressee would have some reason for action to comply with the legal norms. Lastly, one could try to argue by Raz's account of authoritative rules that in case legal directives are enacted by legitimate authorities, this would provide a protected reason for every single addressee. But the problem with that, I will just shortly mention, is that Raz does not require that every single legal directive actually passes the test of normal justification. Neither does he claim that normativity is all about exclusionary reasons. Therefore, this route also does not seem to be plausible to establish the bridge between the social facts and the conceptual truth. There is more discussion regarding these issues, but in the end, I conclude that social fact thesis and the sources thesis cannot accommodate the conceptual truth that I mentioned about the norms. Now I go on with the separability thesis, its scope, and how it's actually compatible with the conceptual truth that I mentioned. Now the first problem with the separability thesis is its scope, because it's not generally formulated as clearly as these other theses are. Therefore, I again engage with works of Matthew Kramer to determine the exact scope of the separability thesis, and I arrive at the conclusion that it actually involves three nexuses, as Kramer himself also mentions. The first nexus is the nexus of law as it is and the law as it ought to be. And this is an ontological claim regarding the existence of the law. Accordingly, the validity of legal norms is not necessarily connected to moral considerations. The most important thing is that in almost all formulations of the separability thesis, we're talking about morality and not necessarily prudence. So what we exclude here as a necessary consideration is not the prudential considerations, but only the moral considerations. The second nexus, which is the morality-prudence nexus, concerns the reasons for action that officials have in order to either comply with the legal norms or to apply them. And the basic claim here of the separability thesis is that moral reasons are not the only proper reasons for the legal officials. It is certainly possible for legal officials to apply or comply with legal norms due to prudential reasons. Basically, the first nexus concerns the existence of the law, because I associate validity with existence. And the second nexus concerns the binding force of the law. The last nexus, the nexus of morality and factuality, on which I and Matthew Kramer kind of disagree, is an epistemological nexus. According to Kramer, Kramer first states that the claim here is simply the following, basically the claim that the determination of the validity or the content of legal norms is not necessarily dependent upon moral considerations. But then he assumes that this is the equivalent of the claim that such validity and content of legal norms can be determined purely on social facts, which is, in my opinion, is not true, because it does not follow from the first expression of the nexus. But I will assume that what is claimed by the third nexus and the last nexus is, I don't know how much time I left, but I'm about to finish, is that moral considerations are not the necessary considerations while determining the validity or the content of legal norms. Again, here, we're not excluding necessarily prudential considerations. This is important because if, in order for a legal norm to exist, we say that it's obligatory that addressees at least have some moral or prudential reasons to conform to that norm, we must be able to use either one of these as indications of the fact that what we have, the entity in question, is a legal norm. And as you can see, because the separability thesis does not necessarily reject the connections between prudence and law, and also because it allows for the reasons that addressees must have to be moral reasons from time to time, although it's not necessary. I do believe that it's possible to reconcile the conceptual claim with the separability thesis. And in the end, because I believe that legal positivists believe in the normative nature of the law, as far as I'm concerned, no legal positivist has openly questioned the normative character, although some of them were not really interested in that dimension of the discussions. And if law is to be normative, it needs to be the formulation for the legal positivism must be able to accommodate the conceptual claim. And this can only be managed within the scope of the separability thesis. That's basically all I need to say for now. If you have any questions during the discussion time, I'm more than happy to engage in them. Thank you very much.
Thank you very much. Debate, discussion now, questions?
Right now? Okay.
Thank you. We got a topic from Lisbon. It was very interesting. I have two questions. One, if you could repeat your criticism of Jules Coleman, because I couldn't completely follow it. The argument seemed to be very interesting. And the other about your main argument on prudential reasons. Would you consider those prudential reasons at the retail level of each norm, or about obedience to the system as a whole?
Okay, thank you very much. Well, you're right not to be clear about what I said about Coleman because of time restrictions. I really said nothing about what he actually defends. But let me just try to explain it in more detail. Well, as far as I remember, without looking at the actual paper, Jules Coleman is actually talking about the practice theory of rules. And it's one of the known criticisms of Joseph Raz that practice theory of rules is not actually compatible with normativity. And it cannot account for the normative nature of legal rules. And Jules Coleman is coming up with an argument that would actually perhaps demonstrate that sometimes practice theory of rules can account for legal normativity. And he's basically speaking about situations where agents need to coordinate their behaviors. For example, during the traffic, you're driving your car and you see that many of other drivers are using the right lane. Jules Coleman's idea is basically that in these kind of situations, a driver would have reason to follow those that drive in the right lane, simply because the coordination in this sense provides security and so on. So that's basically what he means by reason to do as others do. And he believes that, at least in some cases, he's not he's not claiming that this is always true, but at least in some cases, because some legal officials have, with internal perspective, have adopted certain rules, like the rule of recognition or rule of change and so on, the other officials might be under a duty or they might have a reason to do the same as well. So that's basically the core of Coleman's argument as far as I remember. And what I tried to do was to combine it with the fact that legal systems must be efficacious, meaning at least the majority of the populations in majority of the cases must be complying with the legal norms, in order to see if that combination really generates a reason for action in each case where we can speak of a legal norm. To come to your second question, I would definitely consider whether people have reason to comply with the law or not at the level of individual norms and not generally. Because I believe that legal system is nothing but a combination of multiple norms, and what we call legal system is not really any different from the combination of those legal norms. Therefore, the first option, meaning whether addressees have reason to comply with the legal system as a whole, would not make sense in my situation. And that's why basically I would consider it at the retail level for different norms individually. Thank you for your questions.
Thank you very much. More questions?
Sorry, could you please repeat your conceptual claim? Explain why you believe that this claim is conceptual, that is not 100% clear.
Okay, of course. Well, the conceptual claim was basically that if we're talking about a norm, and norms require things, although they may not always conclusively do so, they must at least either provide a reason to take certain actions, or it must be the case that addressees, not due to the norm itself, but due to other norms, have certain reason to follow that norm. In either case, the addressees of the norm would have some reason for action to do as the norm requires. That's why I think it's tautological and almost like always true. The conceptual claim is this, and you asked also why I believe. Okay, that's a difficult question, because why I believe that this is necessarily true, because I believe that norms should be capable of, well, that's kind of circular, I know, but norms should be capable of justifying actions or requiring actions or providing reasons for action to refrain from taking certain actions. And if norms are to be capable, this is the conceptual claim actually, the rest just follows. And if the norms are capable of doing so, it's only by virtue of the reasons for action. So that's precisely why I believe it.
Maybe just one more time, but I may agree with that, provided that applies only to valid norms. In any sense of like moral, legal, and so on. But, so you may have norms which are not valid. I can invent any number of norms which are not valid And I don't think that your conceptual claim applies also to such norms.
Yes, in that case, I would claim that they are not norms at all. I know, it's a cheap defense, but I think it's the right defense.
More questions? I have one question, or the last question. Yeah. What exactly what you consider the best reading of the social sources thesis in the more knowledge formulation of social class? Because there are in the last years, there is a debate about the convenient reading of the social thesis is a ontological reading or an epistemological. Because one thing is saying that the existence of law, existence and content of law, of knowledge, uh, depends on depends on the existence of certain social facts. Only depends on. Without resorting to moral arguments means therefore that moral facts are never grounds. The facts in virtue of I don't know exist biblical facts. This is one really when it is difficult to sustain Ras because Ras in virtue is doctrine of authority, the service conception of authority needs certain dependence, at least legitimate law for us is able to provide reasons for action. And in order to provide reasons for action, it's necessary to be grounded in some set of grounded in all facts, because it's not possible. That's one possibility. Another possibility, and I don't know, recently they like Monty even, we are suggesting that this problem is not our problem at all with a epistemological reading. Why epistemological reading? Because Russ said the identification of the existence and content of law. The identification of the existence and content of law depends only on social facts and not without resorting. And this is an invitation to think that perhaps Russ is thinking and the thesis is needed to establish the criteria, epistemological criteria of identifying law, but not the metaphysical, natural law. That's the suggestion. What's your point? What's your preference about the convenient reading for us and without us? Your opinion.
I mean, to be honest, I'm not really sure in that context what Raz means when he says law.
Yeah.
Is it the sources or is it the norm? Sometimes this is unclear. And if it's the sources of the law that Raz is talking about, I 100% agree with him. But that's not what I'm talking about, because sources are not, in my opinion, the constituent parts of the legal system. It's the norms that constitute the legal system. But I have to think more about it, like not only think more, but also research more about the possible interpretations of what Raz meant by the law in that context. But apart from that, I don't have many disagreements with Raz's theory, as you know. So there are some small things that I would probably choose to do differently. That's why I don't have at the moment, perhaps, a rather clear stance on what Raz meant and whether his words should be understood ontologically or epistemologically. But I do believe that it's pretty much clear from his other comments that he understands the sources thesis as not as an ontological claim, but as an epistemological claim, because it allows for the possibility of the legal systems being completely morally correct or morally ideal simply based on the social facts. And this means that whenever law exists, it will exist in a moral way, like a morally correct way. And that's why I think he probably considers the thesis as you have mentioned, identification of the law and so on, as an epistemological thesis. And that's what I do as well. That's all I can say. Thank you very much.
Thank you. Now we have the second intervention in this first part. This is Rafael Buzón Ibáñez of the University of Alicante in Spain, and the title of the intervention is An Approach to the Concept of Divisibility. Rafa, cuando quieras.
Okay.
As you want.
Well, it's an honor to be here. I'm very pleasure. I thank Moreso and Gonzalo Rosas for accepting me for this workshop. And I just starting for the time, no? Well, the title is An Approach to the Concept of Divisibility, no? And in this paper, in the present paper, I start from the assumption that the so-called problem of divisibility is not strictly a problem of ambiguity of the term or nor of vagueness of the concept, but a theoretical problem. What I mean? I mean that the concept of divisibility is affected, like most concepts, by ambiguity and vagueness, both intentional and intentional, but that we are not dealing with semantic difficulties that we can solve by just fixing a list of descriptive properties, but with difficulties arising from the fact that the properties of the concept are valorative. Why? Well, this is so because the concept of divisibility is inevitably linked to the discussion about the need for its foundation. So we can see that most of the scholars who have worked on this topic agree more or less on the conceptual perimeter of what divisibility is, and yet disagree in multiple points due to the theory of law from which the problem is addressed. So I will try to present a strictly theoretical approach to this issue, setting out the thesis that directly affect to legal positivism, legal post-positivism, and finally, if I have time, the challenge posed by Moreso's inclusive legal positivism. No? I will conclude that divisibility is fundamentally a problem that is internal to legal positivism, that legal positivism, ultimately grounded on conventionalism, cannot account for divisibility in hard cases, that Moreso's proposal of building an image of law in a single level with rules and defeaters must be put aside, and that for legal post-positivism, the problem of divisibility is nothing but that of the rationality of legal decisions, of making implicit law explicit, and that in this regard, there are rational criteria that help to solve hard cases. So, for the topic at hand, we can summarize the general thesis in a very general way of positivism and of legal positivism as follows. Broadly speaking, legal positivism is characterized by being a theory of law that conceives of the legal system as a set of rules understood as norms that correlate the close description of a case with a normative solution. Among these rules, there are logical relationships of deducibility, so that the model of legal reasoning is fundamentally substantive. For a legal positivist, being loyal to a rule is basically to be so to its expression and to its meaning. These rules are not identified by their content, but by their form. And for that reason, they hold that the origins of rule is what determines its legality. All the law is based in conventions, in sources of law. And everything beyond convention is not legal. Hence, a clear case is one which has one conventionally acceptable answer, and a hard case is one that has more than one acceptable conventional answer. So, in this last case, as the legal system, the applicable convention does not determine any answer, for a positivist, the judge has discretion to decide. By post-positivism, I mean, in very general terms, the theory of law represented by Dworkin, Alexi, Carlos Santiago Nino in Argentina, last McCormick, or Atienza and Ruiz Manero in Spain. No? That is a theory of law which holds that besides rules, there are also other patterns of conduct, such as principles, that are norms that establish what ought to be without specifying when their normative solutions are applicable. Consequently, the model of legal reasoning will be subsumption in the case of rules, and balancing in the case of principles. Now, the relationships between norms will not only be relationships of deducibility, but also of justification. Principles give sense to rules. They justify them, and thus the rules are not seen as the product of purely authoritative acts of creation, but as the result of acts of developing, concretizing, and balancing principles. Law is based on sources, and convention, but not everything is convention. Beyond the criteria of formal validity, there are the criteria of material validity, which brings as corollary the problem of implicit law. And taking this issue seriously implies that in law there are no unregulated relevant cases, or, seen from another perspective, that the Dworkinian regulative ideal of the only one right answer is assumed. Cases will be easy if there is an answer provided by the legal system which is logically consistent with other rules of the system and, at the same time, which has value coherence with the principles of the system itself. And cases will be hard when the system does not directly provide a predetermined solution, and therefore it is necessary to unfold an intense argumentative activity to find it. From this point of view, discretion is not pure freedom of choice, but a responsibility of the applicator. Indeterminacy is not confused with uncertainty. As Josep Aguiló argues, the thesis of judicial discretion leads us to the thesis of indeterminacy of law in controversial cases, while the one right answer thesis leads us to the thesis of uncertainty in hard cases. However, legal positivism does not deny that there are reasons underlying rules, but instead, coherently with its conventionalism, it consists of them as more complex facts. It's what in Spain Juan Carlos Bayón called deep conventionalism. Nevertheless, as we will see later, our problem is not a matter of facts, but of method. It can thus be said that both legal positivism and post-positivism are, in general terms, internally coherent, but externally conflicting. Where does the problem arise? At the limits of convention. Positivism chooses the path of discretion and post-positivism the path of coherence with the values and principles of the legal system. Let us look at the consequence. If we follow post-positivist reasoning, divisibility ceases to be seen as a problem of systematic relationships between rules and becomes a practical problem, the problem of implicit law. Implicit exceptions are not the result of the creative and the discretionary activity of the judge, but rather justified reasons, arguments brought out precisely from implicit law. And consequently, the fundamental questions of post-positivism turn on the problem of whether there is or not a rational legal method to explicitly state implicit law. To put it more clearly, from legal post-positivism, divisibility is not seen as a problem of such dimensions. No? It is said that divisibility can challenge the basis of exclusive legal positivism, but as a consequence of law being a social practice. The fact that there is not an answer more or less directly predetermined by the system does not necessarily mean that there is not an answer, but that it will be more difficult to find it, and it can usually be found because there are principles in law. If divisibility is seen as a problem of coherence, of adjusting the directive dimension of rules to its value dimension, the one right answer thesis still makes sense, at least as a regulative ideal. And moreover, in most legal systems, there are mechanisms to adjust the value dimension of law to its directive dimension. It is the case, for example, of a typical illicit act, that is, the abuse of right, legal fraud, and the deviation of power. It will seem that positivist scholars stop at the Dworkinian interpretative stage, when they confirm that there is more than one conventional acceptable answer to a case, and that in consequence, the adjudicator of the law has to choose discretionarily one of those answers. They disregard the idea of a post-interpretative moment, the moment of choosing among these alternatives which is the best, the correct one. But let us continue pulling on the thread of exceptions. The idea of implicit exception itself is directly related to implicit law, which only makes sense to talk about when we try to solve cases using legal rules. For legal positivism, implicit exceptions, if they are not the product of a logical derivation from other explicit rules, since they do not refer to any convention, there is no behavior guide, are inevitably discretional acts of judicial creation. If this is correct, the consequence that follows from it is that positivist legal theory ends its theorization of divisibility at this point. In contrast, for legal post-positivism, implicit rules are those that are neither logical consequence of the explicit rules nor products of acts of will. If we look at the problem from the point of view of the sources of law, which revolves around the connection between legal norms and the processes of which they are a product, speaking about implicit law, product, or about legal method, process, cannot be separated. So having said that, from this point of view, the legal method takes into account, in addition to the directive dimension of rules, the value dimension of law. This means that next to the criteria of normative logical consistency typical of legal positivism, that is, non-conflicting duties, we add the criteria of value coherence, non-conflicting values. Why? Because considering duties independently of their orientation toward a certain purpose has the consequence of accepting that for law, the ritualist behavior is not a deviate form of behavior. But if we reject this image of law and we accept that every duty is linked to at least one purpose from which it gets its cause, law appears to us as an institution primarily aimed at the protection of certain goods. Divisibility from this perspective, therefore, is just another way of talking about the problem of the rationality of legal decisions. If we look at it from the perspective of building and justifying particular solutions using general rules, instead of that of finding in general rules the built-in solution to particular cases, there appears the figure of legal agency, the legal operator or adjudicator, which is completely overshadowed in the positivist vision that we described above. In these cases, the judge has to unfold an intense argumentative activity to justify that there is a normative problem, a gap, from which comes the force of apparently self-contradictory assertions such as the exception confirms the rule. However, the justification of the problem goes hand in hand with the argumentative operations that are oriented to its solution. This is not merely a chronological procedure. There is a constant interaction between the various stages of the argumentative process. There is a recurrence both to the system, to the raw legal materials, and to the various normative propositions that are constructed. The judge has to construct the rule that is going to be the normative premise of his legal reasoning. He has to formulate and justify the rule that resolves the case. Post-positivism has a strong idea of practical reason and of practical error. What is important from the problem of divisibility is to realize how naturally it incorporates it. There are, without a doubt, various illustrations of what I mean. Let us take, for example, the concept of rule in the sense of the normative premise of a finished legal reasoning, as was formulated by Aguiló. No? This notion of rule is a construction of legal agents, contains all relevant factors for the resolution of the particular case, has no specific normative hierarchy, has the force of the law of the whole legal system, and its purpose is to justify the particular judgment taken by the judge. That this is a rule constructed by legal agents is a corollary of all the above. The judge has to decide to use the authoritative material that he has identified as legal. His process of building or constructing the rule is the step or the set of steps that goes from the normative statement to be interpreted to the interpreted normative statement, that is the rule, and the link between them is an interpretative statement that solves a problem of interpretation. To state it more clearly, the construction of the rule is the step from the rule that the judge has the duty to apply to the rule that the judge finally applies. That this final general rule contains all the relevant factors for resolving the case refers to the fact that the judge, in constructing the normative premise of his reasoning, has to articulate and resolve all the tensions of the systematic relationships that arise at the moment of application, hierarchical, semantic, chronological, genetic, and so on, but also the tension dependent on the indeterminacy of the facts and of the law. The consequence of having resolved in the previous step all the systematic relations, include the hierarchical ones, is that this final rule has no hierarchy. It is the solution, all things considered, once the whole legal order has been revised and once the one voice with which the law as a whole has to speak has been articulated. Hence, we affirm that this construction has the force of the law and that its main purpose is to justify the judgment, that is, the particular decision of the case. This concept of rule is thus an attempt to account for the transition for the rules of objective law to the results of interpreting them after all things have been considered. The fact that the law must speak with a single voice is independent of the fact that objective law is unitary. It is a matter of translating the unity of law into action. All systematic and value relationship intentions have already been resolved. And therefore, the conclusion of the reasoning is a practical proposition as justified or correct action. Just for finish, is that the idea that I'm trying to show is that divisibility law cannot be separated from the idea of problem. Defeating a rule always presupposes a problem resulting from a judgment of relevance made by the judge. Legal reasonings begin by being systematic. If the system provides an answer to the case, the judge will limit himself to constructing the normative premise by giving meaning to the relevant legal material provided by the system itself. We are referring again to the process that lies between identifying the normative material and the decision of using that normative material. That is, the step from the raw legal material to normative premises. As Carlos Santiago Nino says, when we pass from the judgment, for example, the Constituent C has prescribed, with quotation marks, no one can be detained without a written order. And he says that this prescription that's not allowed to justify an action or a decision, but one without quotation marks that says no one can be detained without a written order allows it. Why? He explains, it is not only necessary to presuppose a principle of the type the Constituent C is a legitimate authority and must be obeyed, but it is also necessary to have a rule of interpretation that allows to remove the quotation marks that are in the first sentence. So if the system does not give an answer or gives an evaluative and acceptable answer, we consider that there is a problem. And again, the fact that this problem does not have a predetermined solution does not mean that the law is undeterminate, but that it is uncertain. Thank you very much.
Thank you so much. Rafa, now, questions?
Thank you very much, Rafa, for your presentation. I have two short questions. The first one, you said that authors are in agreement on the notion of divisibility. What authors are you thinking about? Because if I think divisibility as what the Almeidas, I think it has nothing to do with divisibility as hostility, dissociation arguments, or pronunciation. So which kind of agreement are you thinking about?
It's very extreme position.
Yes.
Some relationship there is, no?
Yes. What notion of divisibility you're assuming? And the second question, I'm having problems to see the opposition that you're trying to construct between divisibility in legal positivism and post-positivism. So if I understood you correctly, in post-positivism, divisibility is the explicitation of implicit law, right? But if I took legal positivism, classic legal positivism, Churro, for example, I'm using the notion of divisibility. It's antecedent with explicit conditions accompanied with implicit conditions, and I represent it with a revision operator. So, what is the difference then? Where is the contrast between these two ways of understanding divisibility?
Okay. Well, the first question. It is true, but I think that your position is a extreme position. I think that there are many connections between Duarte Almeida or other authors. If not, they won't write in the same book, for example. No. So I just wanted to, and in the paper I put in a note, no, that if I'm not going to enter in every difference of problems and currents that have been generated by a whole bibliography that I think that it's normally linked to legal positivism. So why? Because the questions that legal positivism tries to answer, I think that are not correct from a post-positivist approach. And from a post-positivist approach, divisibility is not that type of problem, because we have principles of law that give sense to rules. And I think that the problem that, for example, your position that I know is that you need something that gives sense to that rules. And you are looking for it, and so the only way that you have to answer is to say the judge has this question, and just his preference, and whatever, no. And the second point is that the opposition, what Ron says, it is true, but that was the last article of, I think, the last article of the last paper of Arthur Wrong, that he says more or less that Dworkin has risen, more or less. So, as Atienza, for example, says, we agree the position of that last Arthur Wrong. We think that this is correct, but the problem is that that process of interpretation that Arthur Wrong puts. How do we do it? How do we do this process? And I think that there are rational. This is a problem of legal method, and there are rational criteria to solve it. That's a problem. But I also agree with that last Arthur Wrong, but not with the first Arthur Wrong. Thank you.
One manifestation of that. The last one to run.
It's a law and logic, the paper.
The last one to run is on law and logic criteria. The last one to run is true that represents certain change, consequence of the series of papers of the feasibility of what to run. But what to run has one point in some sense positivity, in some sense, because the feasibility is possible for us to run as a dispositional approach, in the sense of the implicit conditions which are in some sense related to the even contrafactic will of the
Yes, the intention of the intention.
And in this sense, is more positivistic than other positions, more related, for instance, for working, this is not the West, the question is in the best interpretation of this life of this disposition, which is the solution, which is the right answer, independently or with certain independence of the disposition of the system. I think it's
Yes, but the problem is what is. Yes.
The last one.
Yes, but the problem is what is Arthur Wrong understanding by implicit exceptions? Because if implicit exception, as in the tradition of positivism, is just the logical derivation of explicit rules, that is not the notion of implicit exceptions for legal post-positivists. That are the position between rationalism or deductivism and judicialism. That is what post-positivist tries to construct, a middle position that takes part of the two of them, and they are neither logical consequence of the explicit rules and not products of acts of will. That's the point. No? We try to solve from the point of sources for law of rationally explicitating the implicit law. Thank you.
One question.
Email.
Yeah, email.
Thank you. Congratulations. Should repeat something that I always find troublesome. This idea that working is usually a regulative idea. And then later we can talk working into the completely ideal one. And I don't think that's what he's saying now. I think it's completely committed to the right answer thesis, and it's not against the regulative idea. So what do you take the idea that you have a follow-up?
Well, I think that I am more in the position of Alexis, no? Not of Dworkin. I think that the idea was from Dworkin, but I postulate as an ideal. The ideal of the regulative answer, for example, is the only way to give sense to the debate between collegiate tribunal. For example, if three judges to resolve a case in an audience has to argue to find what's the answer to that point, the only way to understand what they are doing is presupposing the ideal of the correct answer, and not that they just want to articulate their own position because that's their position. So I think that is like the in English is how do you say pretensión de corrección in English? The claim to correctness, the claim to correctness of Alexis. I think that is mostly the same idea.
So what about if thinking into more in terms
Could you
of-
speak more?
Sorry. So what about thinking it more in terms of you people decide, you people resolve, and the people provide the law to decide according to the law. You don't have to throw yourself into the ideal and so on. I think you can move to another direction. But as you said, it's fair enough to say you're going more into Alexis.
Yes.
And that's, I think, Alexis from there. So why not move to one?
Well, I have to think. Thank you.
Some questions, anything else? I have, no,
In the top, I think maybe somebody,
sorry.
but maybe somebody.
In the people online. Gonzalo?
There is,
There's a
Do you help us?
we have a notification.
Yeah.
Or-
Yeah.
Can I stop sharing? And here's chat.
No, but don't worry.
No.
Please
No,
proceed.
no. That's okay.
But
One final question. One final question. Well, I don't know if you intend in the paper these considerations at the end, but the problem with this standard image in the last years of law, that law is I don't know, two-story building, a building with two floors. Two floors, in one floor there's books, and the other floor there's principles, and that's, there are principles, and that's the idea of exit building, and working also. Working once years ago, the commercial said, this is the archaeological part of my theory. This is just it grows the principle, but and in our countries, in Spain, Italy, Latin America, this is the standard image. I thought, I think that there is a problem with this image. A problem, in fact, a lot of times underlying. The problem is, and you said, rules requires subsumption, principle requires balancing, and it is different. Well, but one of the main uses of principle is accepting rules, is making exceptions to rules, and how to explain this relationship between principles in the second floor and rules in the first floor. These floors has no communication, and one is a principle accepting the rules. This is an operation of subsumption or balancing, and that is not resolved in Manila Pinza, de manera las piezas del derecho, the statement, no? As the legal statement, a theory of legal statements. They say that in this case there are also a conflict between principles, between the principle in the playing and the other principle according to we should obey the rules. And this is the general principle. But the principle we should obey the rules is a principle not requiring anything different than the rules. This is the conflict between the rule and the principle. And this is not easily explainable in this approach. For the reason I suggest, come back to the one store building, but very important, not only with rules, but also defeaters. And defeaters are authorization channels to go to the underlying reasons and apply in another way. But this is a suggestion. because if not, his image is the standard image, but there is no a clear even working when once is pressured by this idea said, well, perhaps after the decision Riggs versus Palmer, the rule changed. Said, but if working acknowledged that the rule changed, that it is a disaster for working. Because working is intending that there is the criticism to this absence of distinction is the ex post facto law. Ex post facto law, if the rule change, is an application here or ex post facto law, because the moment of the will of Riggs, there is no the rule because of the change. That's the problem.
Okay.
I don't know what's
Yes. Well, maybe the position of Atienza and Rimanero may be developed. I don't say that, but I don't.
Maybe changing the position.
No, I don't think that they have changed. But you speak about the institutional principle, and I think that that's the point of Atienza and Rimanero that have to be developed. No? But what finally you advocate just for a model with rules and the way of activating their exceptions. No? In the same building, that without collapsing into a jurisprudence of reasons. You say that. No? Well, I think that it's not correct. Why? Because the reconstruction of one level model with defeaters obviates one of the fundamental reasons why post-positivist scholars use a two-level system, precisely within the framework of a constitutional rule of law. Why? Because rules are nothing but the results of the balancing of principles, and by definition they cannot be in the same level. By definition, they cannot be in the same level. No? Why? Because principles give sense to rules and justify them. And secondly, that construction of defeaters only accounts, I think, in your case, for explicit exceptions. And the mechanism that are already provided by the system. But I think that the problem is when there is no legal convention applicable to the point. No, I ask you one question: what happened in this zone of entrance of defeaters? Discretionality or right answer in material terms?
No, that's okay. There is no the question of whether it is not. And the question is why one approach like this only is able to take into account explicit defeaters.
For the type of defeaters, the cancelling defeaters, excusing, the overriding.
Depends on the concept of defeater. Depends on the
your classification of defeaters.
There are defeaters, for instance, arising from the judicial practice, arising from the sense of legal community, like said in the case.
I am speaking about your classification of defeaters. I am speaking about that: the cancelling, the excusing, and the overriding. The two decisions. That is the one that you construct.
Yeah, that's true.
And for example, causes of justification in criminal law. That's explicit law.
Even that is not true
It's a lex posterior.
Yeah, but even that is not true in German doctrine. German doctrine accepts all the people, the extra-legal justification. All the people, there are.
Me, that's not a problem.
But I mean, there is nothing in the notion of justification process that makes that they should be explicit.
Okay, I don't have problem with that.
Oh, but I am not committed.
Okay.
I am not committed with the idea that all the defeaters are explicit. I am not committed.
Okay.
That's my position. That's okay because this is there is no sense. Thank you very much. Thank you, Rafa. And we are going to the second part of this session. Thank you. Second part of this session. Now, from the University of Lisbon, in Portugal with Pereira Coutinho, legality as inert. We have 2 sessions more after Melanie and Alberto Pupo. Who's here? Well, hello, everyone. I should say from the start that my background is not really in legal theory. My background is in constitutional law. Perhaps that's the reason why I'm bringing an orthodox reading of Hart. Perhaps you'll see the vice of people when reading other authors from other fields is to apply their own frames, but I still think that it makes sense, so I think it would be interesting to test this idea here with you. So I thank you already for your attention. Well, there are 2 possible understandings of the separation thesis. In a first version, the validity of law does not depend on the morality of the corresponding norms. In a second version, the validity of law does not depend on the moral or political value of its sources. The first version corresponds to a definitional thesis of legal positivism, the sources thesis. The second corresponds to an orthodox version which understands legal sources as pure facts. The second version reduces the rule of recognition to a pure matter of fact, that is, to a mere description of law-generating facts, of sources of law, as they are accepted in legal practice. This is the understanding I will discuss here. I will propose an alternative understanding of the rule of recognition as a discourse. I should clarify that discourse, as understood here, is a constitutive language or speech on the existence of a given order, and also on why it should be obeyed. Regarding law, at issue is a speech shaping an order whose valid existence as law depends on certain conditions determined by it. Within this speech, the verification of these conditions makes obedience to law rational or correct. Those conditions may be exhausted in the pedigree of legal norms in their derivation from legal sources. But in this context, legal sources cannot be taken as mere facts. On the contrary, certain facts are considered as legal sources within an evaluation made possible by the said speech. Moreover, the very notion that legal validity depends on the pedigree of legal norms will only be understood with reference to corresponding values or reasons. I believe the conception of the rule of recognition as a discourse is the one that more accurately portrays Hart's own position. That is, for Hart, the rule of recognition is not a mere description of legal sources taken as facts. He does not defend that there is a determination relation between mere facts, those described by the rule of recognition, and the validity of legal norms. Nor does he defend that legal officials consider this relation as correct simply because the same is followed by other legal officials. If this actually were Hart's doctrine, it would be refutable. In fact, it was convincingly refuted by Mark Greenberg, who proposed in alternative what he names as the rational relation doctrine. As Greenberg pointed out, descriptive facts cannot determine their own rational meaning. They cannot even be identified as sources of law without there being reasons why they should be considered as such. If Greenberg is right in the rational relation doctrine, he is wrong on Hart. As I said before, Hart never actually defended a determination relation between mere facts and legal validity. Remember that Hart identifies the rule of recognition
with, quote, the internal statements of validity made by those who use it in identifying the law, unquote. Moreover, Hart maintains that a lawyer who tests validity by reference to the rule of recognition presupposes, quote unquote, the latter. That is, he leaves unstated, new quote, something that could be stated. If challenged, what is thus left unstated could be established by appeal to the actual practice, Hart says. In other words, the existence of the rule of recognition can be proved by appeal to the facts. But these are not the rule of recognition itself. Hart clarifies even further by saying that the question of the rule of recognition can be placed as a factual question only if it is put as a question about the existence and content of a rule. The rule of recognition is therefore the object of the factual question and not itself the factual question. One cannot confuse the proof of something with that something in itself. From all this, one can infer that the rule of recognition corresponds to internal considerations on legal validity that are generally left unstated. That is, it is a language or a discourse that evaluates facts as sources of law. The corresponding evaluation makes it rational that they determine legal validity. This version of the doctrine of the rule of recognition escapes the objections that are usually made against the first version. Essentially, legal officials will not be taking as prescriptive something that corresponds to the mere description of their practice. The rule of recognition will correspond instead to a prescriptive language, structuring the legal practice. This will explain the coincidence between the practice as it is and the internal point of view of its participants. The discourse that structures the practice is also the discourse that is internalized by the legal officials. Nothing of the above is meant at denying that Hart is a legal positivist, at least if one understands legal positivism as a descriptive thesis of law that can be essentially formulated as the sources thesis. The point is that the law that is being described, or its validity, is not itself a descriptive reality. Rather, it is a reality constituted by a language which refers its validity to sources of law. And since this language is internalized by the legal officials, it is rational for them that some facts identified by it count as sources of law. It is important to mention that the rationality of legal officials is being understood here as a historical rationality. That is, the discourse that makes something rational is taken here as a product of history. In truth, a historical rationality would be incapable of dictating which facts are to determine legal validity. It would even be incapable of dictating the source's thesis itself, of establishing that the validity of law is to be referred to sources of law and not to the content of law. One may say in this context that Hart's legal positivism supposes that legal officials have internalized legal positivism as a historical discourse on law, moving within the corresponding rationality, the one dictating the sources thesis. That supposition is not implausible if one considers that legal positivism, more precisely classical legal positivism or political positivism, actually is the discourse that shapes modern law. It is the discourse on which, therefore, the legal officials' Hart has in mind were born and bred. At this point, it should be mentioned that the founding fathers of legal positivism were fully aware that they were articulating a new language of law, a new political discourse that is constitutive of law. They opposed this discourse to the jargon of natural law. I'm using Hobbes's own adjective here. Moreover, Hobbesian positivism articulated the political values according to which law, valid law, exhausts itself in positive law. I'm speaking of sovereignty and representation. The rooting of the validity of law in sources of law must be understood in this light. That is, some facts are sources of law because they are facts of sovereignty, mediate or immediate ones. It is the overwhelming historical success of legal positivism as a political discourse that seems to be confirmed by Hart. Remember that Hart takes as his object of analysis not any law in itself, but the discourse of law. That is, he takes as his object of analysis the language of law that is used by judges and lawyers. To the degree in which this language coincides with classical political positivism, one may say that Hart's conceptual positivism portrays its historical success. Hart is describing the internalization of modern positivism by those participating in modern legal practices. I'm not suggesting here that there is an identity between Hobbes's and Hart's perspectives. Hobbes' perspective was, as we all know, a normative perspective. It determined at the dawn of modernity that only positive law should be taken as true law. Unlike Hobbes, Hart's perspective is descriptive. At issue is not restoring Hobbes' normative positivism. It is merely to register that the corresponding discourse is the one that structures modern legal practices and is internalized by legal officials. That is, Hobbes' normative conception was transformed by history into a concept shared by those who actually speak the language of law and thus assess the validity of law. Against this reading, one could point out that nothing can be read in Hart about sovereignty and representation as political values. One could also claim that Hart's legal validity is to be taken as inert, using Gardner's expression, an inert notion with no correspondence with political legitimacy. I respond to these 2 points in my written paper. I will only point out here that to mention the Queen in Parliament as the rule of recognition means to mention the political discourse of sovereignty and representation. More precisely, these are the values internalized by those who accept the authority of the Queen in Parliament. These are the values that remain unstated when someone states the Queen in Parliament. Regarding the second objection, the descriptive nature of Hart's thesis does not imply that legal validity or legality is inert or divorced from legitimacy. Unless it is not a true one, a description, I've already said this, cannot override what is being described. In my view, Hart does not make that mistake. The legal validity that is actually described by him, that is assessed under the rule of recognition as a discourse, is not inert. It corresponds instead to the legal validity prescribed by classical positivism, since, again, that is the discourse internalized by legal officials. Going back to the question I started with, what I said implies a rejection of a radical understanding of the separation thesis, which takes legal sources as pure facts. Legal validity, legality, will always depend on the evaluation of certain facts, an evaluation that makes it rational that they count as legal sources. That evaluation is made possible within the rule of recognition as a political discourse of sovereignty. The question that must be placed at this point is whether that discourse admits the dependence of legal validity on criteria other than legal sources, namely moral criteria. Do I still have enough some time to address this last question? Okay. Well, as we know, Hart is not entirely consistent on this matter. But in my view, the question can only be settled in light of the rule of recognition as a discourse of sovereignty. In that light, in my view, Hart's first indications prevail over the postscript, because unlike the latter, the former accurately captured the conception of legal validity that is shared in legal practice, in a legal practice whose participants have internalized the discourse of sovereignty. From this perspective, only an improper rule of recognition could establish moral criteria. In a way, perhaps a paradoxical way, I am confirming Joseph Raz. In my view, Raz's thesis on the authority of law is dependent on the internalization of a discourse of authority, on sovereign authority by the participants in legal practice. And if one accepts this, Raz's conception, unlike what, for instance, Leiter says, his conception will still be descriptive. It describes the conception of authority that is shared by those who were born and bred in the political discourse of the modern state on the rule of recognition as a discourse of sovereignty. Just one final note, it is important to remember that in the modern discourse of sovereignty, the mere consideration of the law as an expression of sovereignty, is a sufficient reason for action in accordance with it. By surrendering their own practical reason to the reason of the sovereign, as expressed in the law, legal officials and also citizens are guaranteed to act in accordance with reasons that are public. They thus avoid the divisions that would inevitably result from pursuing their own private reasons, namely their own moral reasons. It is this sort of discourse that, in my view, corresponds to the rule of recognition. Thank you so much for your attention.
Thank you, Luis. Question?
Thank you for your presentation. It's certainly very interesting, especially for a scholar like me who's also from constitutional law background. But there is one thing that I don't understand. Yeah, sure, sorry. And I may be horribly misunderstanding your point, but let me just formulate the question. Why would the fact that certain values, not necessarily ideal values or moral values, have been internalized by a certain class of legal officials, would be described better as rational and not as merely a fact? Well, just in addition to that, there is discourse, but there are also rational rules about the discourse itself, just as there are rational rules about how law ought to be and so on. So the only thing that I don't see is why we would need anything else other than the description of fact to describe the internalization process that you have just mentioned. Maybe I misunderstood.
No, you're not misunderstanding at all, and it is a very interesting question. Well, I take rationality as an historical rationality. Human rationality, from this perspective, is an historical product. We call something rational because we internalize a discourse in which that something is rational. I think that to call that a fact would be very impoverishing, because one has to understand the complexity of the phenomenon. Perhaps we could call that a fact if one supposed metaphysical rationality above that historical rationality. Well, but what would be the point of calling this a fact against the metaphysical rationality, if calling this a fact would prevent us from actually understanding the complexity of the phenomenon? So I don't know if I'm addressing your question, but I think that it's more clarifying to call this rational, taking into account that rational here is not a metaphysical term, but a term pertaining to a discourse which makes up human rationality.
Yeah, I have a question. And I think you touched subjects in your presentation, but I would like to invite you to talk a little bit on that. And the question is basically which political discourse? Because as I see it, when Hart tries to establish the validity of norms, he uses, of course, the rule of recognition, but when he actually is explaining individual examples, the idea that comes towards us is more like the validity is given by rules of change and not the rule of recognition in itself. And that's why I think Boggio says that the rule of recognition will have no function at all, rather than identifying the first act or norm that established competence to create other norms. By and this is important because it proves that the definition of a legal system must be towards a constitutive rule, and you approach this idea with your political discourse being a constitutive speech. My question is, what enables the existence of this political discourse, and why one discourse and not another one? What is the foundation of the legitimacy?
Well, why this discourse, not another human being? This is perhaps a metaphysical thesis, but we are historical beings. Natural law discourse is a discourse, but it is not the discourse that dominates our world. Our modern world is dominated by positivism, perhaps because, for good reasons, probably. But on your point, the rule of recognition, even if I don't agree with Gardner in most of the things, but there is his analytical perception that the rule of recognition belongs to a species apart from the other, from the other secondary rules is right, because even the rule of recognition legitimates change according to the rules of change. But the point, what is this discourse? This is the modern political discourse of sovereignty. This is the modern political discourse of sovereignty, of the state as a rational structure, of modern of law as a product of that rational structure. This is my best shortest answer. Of course, I could speak the entire afternoon, but there are.
I have one last question. I think so, and it's very clever and very interesting presentation. Your reconstruction of Hart's positivism is like a kind of so-called now normative or ethical positivism, where you, like, it's similar to working, because working wrote after was script one paper for Hart's political philosophy, something like that, in Oxford Journal of Legal Studies, where is a chapter after is a chapter in justice in law, and in working say, well, how is possible to make sense to the legal activities in the present day, and say from political philosophy, from one position in accordance with this normative positivism is a reconstruction of the law in a democracy with democratic parliaments enacting laws and the generation of this acceptance in this conception of sovereignty, as you said, conception of sovereignty. And this is also one way to limit the power of the city. It's also that. It's also what it said Working does, it's obvious, Working didn't agree with that, but he considered that the best reconstruction of the legal positivist, hard legal positivist, is this normative positivist after defended by David Waldron or Tom Campbell or something like that. I'm not sure, but perhaps you're thinking some similar because you're thinking.
Yeah, I think you would be right. This reconstruction leaves Hart in the way of I end up understanding him as a normative positivist, but a descriptive normative positivism, because he's describing that normative positivism has been internalized by the practice. That's the only twist here. And on the second question, would this limit the authority of the judiciary? Well, that's a tricky question. Not necessarily, because the sovereign here, the Hobbesian sovereign, was transformed in the Carré-Malberg state with the different powers. This is the sovereign structure that produces law and all these kinds of articulation. So, not necessarily. But the discussion would be different. What sorts of reasons can the judiciary use? They are still public reasons, and that's the problem, can they use our moral arguments? And that's the problem within the discourse of sovereignty. But not in principle. The structure can be much, much more complex.
Thank you very much.
Thank you.
Thank you. Thank you. Now we are going to the final of the session with two sessions more. Now, Melanie Berlin Andrade from Federal University of Paraná of Brazil, and the presentation is legal positivist and inclusive. No, legal positivist institutional morality.
Institutional morality, the Brazilian case.
Institutional morality, the Brazilian case. Melanie.
Right. Good afternoon. I would like to thank you, Professor Moreso and Professor Gonzalo, for the opportunity and all the presents for being here. My paper is called Legal Positivism and Institutional Morality, the Brazilian Case. The goal of this work is diagnosing the difficulties concerning both identification and recognition of institutional morality in the Brazilian legal setting, proposing a McCormickian framework for an inclusivist, positivistic legal theory appropriated to that reality. For this, I will start from Neil McCormick's theory in his inclusive positivist phase, especially regarding the ideas contained in the work called An Institutional Theory of Law, published in 1986. In this phase, there is the overcoming of the positivist theory of law through a contingent relationship between law and morals, and he may be considered an inclusive positivist. In order for fundamental background rights to be brought into the realm of legality and become directly relevant to the solution of legal disputes, McCormick argues that an ideal moral theory must necessarily be transformed into a theory that he calls institutional morality. To me, the concept of institutional morality is the way McCormick formulates a contingent relationship between law and morality. Institutional morality has two dimensions. On the one hand, it must fit as closely as possible with the legal and political institutions of a given civil society. On the other hand, insofar as it is consistent with this requirement of adequacy, it must come as close as possible to our idea of background political morality. This concept comprises a set of principles designed to make maximum moral sense in the political institutions. Institutional morality is, thus, ideal morality relativized for a particular set of political institutions. McCormick claims that institutional morality is visibly essential to all deliberations on difficult problems in constitutional law. Where there is constitutional law, there must be a constitutional theory, and, in turn, a constitutional theory necessarily is rooted in the vision of a constitutional state that is or aspires to be a moral order. McCormick argues that positivism is indeed capable of understanding this constitutional depth. For a crucial question would have escaped attention, namely, an institutional morality is the morality of what? And then I quote McCormick's answer. The question seems self-answering. Institutional morality is the morality of the political, legal institutions, of the civil society and view. That is, it is the set of moral doctrines and principles which best fits actual existing institutions, at the least sacrifice of an ideal or background moral view of how life in organized society ought to be for individuals. There needs to be reference to certain institutions in order to filter out from a fundamental morality a set of principles that fit the institutions in order to generate their best possible justification, and then to follow some procedures that must necessarily exist to identify the institutions independently of any prior original background morality or institutional morality a fortiori. In Brazil, the principles are widespread in its constitution. However, they are not simply positive customs as in the common law systems, but they are ideals enshrined in law for the country's future, given the context of social rupture in which they arose. Because before the Constitution of 1988, the country was ruled by a military dictatorship. As of today, the moral content of these principles is still object of dispute, and we have an inconclusive debate. And a current Brazilian institutional morality cannot be identified yet with clarity. So the present investigation's hypothesis is that the lack of recognition or identification of a Brazilian institutional morality results out of the practice of dealing with an entanglement of morality and law, which arises central questions in this contest. The first one is, how does the idea of institutional morality impact the relationship between law and morality? The second is it feasible to improve institutional morality and how to do so? And the third, how does such theoretical framework play out, considering the thesis of separability, the thesis of social sources, and the thesis of discretion from an inclusive positivistic point of view? The research results summarize. 1. To this moment, there is no clarity on the moral preconditions assumed by Brazilian institutions, considering the lack of an adequate framework to deal with institutional morality, although democracy is still a high value. The second, two assumptions should be made and should be considered as the country moves forward. The first one is that moral objectivity is possible to achieve for us to come from certain place. And the second is that democracy and pluralism are negotiable conditions. And in order to guarantee pluralism in the public debate, I suggest the adoption of the argument formulated by Professor Mereso, which he calls redictio ad Hatzingerum, which means that those whose ideas are against pluralism should not participate of the public debate. And now, going to the end of this presentation, I'll provide a simulation of the behavior of the judicial actors based on an improved concept of institutional morality, considering the three legal positivist ground theses. The first one is the separation thesis. Institutional morality implies a contingent relationship between law and morality, since law may come to be identified from it, but not necessarily. The second one is the thesis of social sources. So, law is a conventional phenomenon. There are conventions shared by a certain group that allowed the identification of the law, and ultimate validity criteria are allowed, which may incorporate institutional morality and may integrate the content of constitutional legal restriction. And the last, the thesis of discretion, institutional morality is presented as a limitation to judicial discretion, while directing and giving content to the law. There will be not only one, but several correct answers, although always reaffirming the rights in dispute, leading to a coherent institutional interpretation of the law. And now, I'm just to end the presentation, I'll expose for you some topics that I'm thinking and studying right now from all the things that I said before. So the first one is how to make the transplant of the theory, because we have different situations considering the places where the theories were developed. The second is, do we need to recognize or do we need to construct an institutional morality? The third is, if the content of rights is in dispute, how to create elements and tools to deal with these disputes. The fourth, how to deal with the fact that nowadays the institutional morality is the one of the political group that is transitorily in power. And the last one is how to do it, considering the socio-political history of Latin America, especially Brazil, that we have social inequality, Catholic religion mixed with politics, a history of patriarchy, and a history of racism, for example. So that's my presentation. Thank you very much.
Thank you very much for your presentation. Questions? Follow. I am not able to see you.
It's just a clarification question. And for me, it's not easy to understand what is exactly moral institutionalism or the institutional foundation of morality. That's the first one. And second, I cannot understand why it's possible to talk about our national institutional account of morals.
Why is it possible?
Why is possible? Because you say that there is like a Brazilian institutional morality that is different from the Colombian, that is different from Spain, and that is not easy for me.
Okay. So the institutional morality is that background morality when all the laws lay, the juridical system lay, or but as for example the theory of the working, he talks about that background morality. That would be a kind of institutional morality, as McCormick comes from this position. But my defense is that we can integrate, or we need to be coherent, deciding on identification or identifying which is our direction. For an example, to be easier the comprehension, to ease the comprehension. In England, you know that it's clear that they are liberals, for example, and all their law, all their rights are interpreted by judges following this moral consideration, this moral background. But now, in our country, as we are still in a new democracy and we are still constructing our background morality, I would say something like that, it's incoherent. So depending on the group that is governing Brazil, all the laws and the interpretations change. So, and a very simple example from ours. We had before Bolsonaro, that is our actual president, we had a party that was a left wing, and now we have a right wing. And before we have a politic for no guns, and now we have a politic to arm the people. So what is our direction? Are we a peaceful country that doesn't want armies or guns to the population, or now we have 7 laws made by the president allowing it? What is our direction? Because when you have to interpret the rights and the content of principles, we need to have some security in that for the future. So this, how I defend that identifying or constructing this institutional morality, it will be easy to have security or coherence in the decisions. It will integrate the law in a certain way, although it's not necessarily this connection. Can you make it clear?
I have one question related to that question, and one question and actually an answer to Gonzalo. Well, the question is how we should understand the idea of institutional morality. It's possible that there are objective institutional morality different among them. One for a country according to the tradition of this country, another for another country. That's possible.
Yeah.
I think it's possible in one sense. If we accept that there are multiple ways to develop and to implement different the same values, And even, but perhaps it's not necessary, even that there are certain incommensurability among values, but perhaps this is not necessary. We have situations understandable from this point of view. For instance, France in Europe has a very strong secular tradition. Fascist, very strong. And for the reason in France, I consider that the religious symbols are excluded of the public space. For instance, in the schools, there is prohibited the Salvador, but also the Catholic representation and so on. Is prohibited. And there is prohibited, and for instance, in Germany or in Spain, it is not prohibited. Germany has not this very strong racist tradition in its political history, and there is permitted, in fact, there is permitted to the students and to the teachers going to the school with a salon. And the European Court of Human Rights said it is possible because it is the margin of appreciation. This morning, let's us refer to the margin of appreciation, this mysterious doctrine of the European Court. But one way to understand, one of the last papers of Rosas suggesting that one way to understand the idea of national position is saying we need to account the tradition and the evolution of each country, in order to determine how is better to implement freedom, religious freedom, because perhaps it's different in France and in Germany.
Of course.
And makes sense. It makes sense, and in this sense, institutional morality is peculiar to one tradition, even if is objective, because in France is correct in this way, and in Germany in the other way. It's not it's not a relativistic conclusion.
Yes.
It's not a relativistic conclusion. Perhaps this is one idea that you could accept in order to make sense to the idea of institutional morality. I'm not sure, but perhaps it's one idea that it's possible to understand that the institutional morality of the country A is different than the institutional morality of the country B, but this depends on the tradition and the political ways to implement the values, even if the values, the nuclear, the crucial values are the same.
Yes.
Are the same for all. I don't know. What's your idea about that? Melanie?
No, I think they are different. This is, I assume, as truth. That's the reason why I'm talking about the case of Brazil. And it can be very practical, as you said. But can you see that in the examples that you gave, you already identified the institutional morality of each country? And for instance, when we are talking about healthcare, you have to know as a judge if you're inside a welfare state or a liberal state, because the decision will follow a different way, an opposite way. So in cases like this, and I believe that all institutions, like all the public administration, must be current. In cases like this, it's very important to understand what is that compromise that the society had made. And I think that is our problem. It's not clear yet But I don't know if it's a case to identify or if we have to understand the problem and start to trying to find out, or if the judges are going, the ministers of the Supreme Court are going to construct this argument. I'm not sure yet.
Thank you very much.
Bertrand,
That's
please.
Bertrand Gonzalo, professor of University of Berlin. I have three questions which are combined to each other. So I completely buy that there are some paradigms within different countries from the institutional settings and the normative approach to that. But actually, so what is the historical development? So could there be a plurality also of different institutional normativities? Could there be a change in a way? So the change, I think, is quite obvious, but could there also be a diversity? So could different institutions, for example, the Constitutional Court and Parliament or whatever, have different normative background, tribes or whatsoever? So this is the first question. The second is, if you talk about institutional normativity, I understand that's coming from economics theory and is a theoretical construction. But nevertheless, if you're doing it as an argument of paradigms, where do you look for the empirical evidence? So where do you look at for really saying, well, this is now the institutional background paradigm? One information from William Ellis Chang, Law and Political Economy, they look, of course, for different, and you mentioned one of the arguments, like a welfare state. So you could look as the arrangements, the board institutional arrangements, and then look how they develop into economic history and into political history of ideas. And this is the second. Third combined is, I have another idea of how you could look at it, and that's also a question to the form of the background institutions. So is there any link to an idea of a theory of principles, for example, of reasons? So, for example, another way to look at it could be, which are the reasons normally used in courts or in legislative motivations of legislators? And are these reasons, for example, more freedom-oriented, liberty reasons? Are these more stability, security-oriented? I don't know. And so you could also make a structuration of the institutional background ideas towards that.
Okay, so yes, I think that the parliament changes a lot, but it cannot, and the government changes a lot. The ideology of the government changes a lot, but it must be something concrete in all of it. The problem is just that, is that changing. But I'm not sure which institution should hold the duty to be coherent and to make this work. In my, of course, in my thesis about it, I used some decisions, contradictory decisions. We have two highest courts in Brazil, the Federal Supreme Court and also the Court of Justice. And I showed that they have completely different position at same aspects. So this is a problem because you have no security and you can't see the direction. And I show also the problem of the ambiental code. I don't know how to say that in English, that talks about nature and all this stuff. It took 15 years to start to be applied because one institution, the prosecutor, didn't accept and then started to fight about it in court. And then the Supreme Court made a decision, a huge decision, bigger than the code itself, explaining how it would be applied and changing a lot of things. So some people made the decisions according to that code that after that had changed everything. So are we going to protect nature, or are we going to protect the enterprises, the agriculture? What is our position in all of that? So the problem is that the reasons, as you told, are incoherent now. That's why I'm having this difficulty. And the courts decide in a different way. Depending on the state, depending on the minister, depending on which, it's a little bit of luck, and it can't be that way. So that's the problem I'm working on. Thank you.
Thank you very much. Thank you. Thank you. Now the last presentation today and in this workshop, the last presentation, Professor Alberto Pulpo from the Instituto Tecnológico Autónomo de México, and the session is Hebrew expressions difficult to me, SEDEC and Mishpat, the connection between law and morality in the Old Testament, from Mexico to the Old Israel.
Well, just 1 second in order to catch a little document that I will project with some quotation. Another option is just announcing the coffee break at 4 o'clock, but I can't see it. No, it's not Google. No? It's just okay. Okay.
I also have a pen drive because it's better. It's better. It's safer. But I know. Usually.
Okay. So if you just can manage this. Well, thank you very much for being here, and sorry for the late presentation, but it's not really my fault. So I come from Genoa, so a very deep place for legal realism. So it is maybe something crazy that I will talk about the Old Testament. But in a very, very little nutshell, my idea is that even if we go to the Old Testament, we encounter exclusive legal positivism. So even with divine law, even if we take seriously divine legal sources, we find very strong arguments in order to defend an exclusive version of legal positivism. So how can arrive to this conclusion? In a recent paper, Doing Justice, Judging, and Jewish Values, Judith Bartnoff, a US federal judge, tried to explain how, in her day-to-day job, the Jewish notion of tzedek played an important role. That is unusual. Usually, when we talk about justice in court, we have as reference Dworkin, eventually some anti-positivist authors, but not the Old Testament and not on the lips of a judge. So in this work, I will offer an interpretation of the relation between two key concepts, tzedek, the first, and mishpat, the second, both usually translated by the term justice. But I will try to show that the translation by justice is just a very huge source of ambiguities. So I think my analysis can help to a refreshing, at least a refreshing understanding of the classic debate about the separation thesis. My final claim is that the legal theory expressed by the Old Testament shares a lot with exclusive positivism with a clear realist approach, despite the obvious role played by God's authority, of course. The first step of my reconstruction is a brief description of the plurality of meaning and of translations. It seems to me, on the basis of a comparison between at least 4 languages, English, French, Spanish, and Italian, that translators have a lot of imagination. Despite the erratic translations, or maybe because of this, it is easy to mark an intuitive difference between Tzedek and Mishpat. Assuming that both, without making big mistakes, can be translated by justice, we can distinguish between 2 dimensions very familiar to any legal scholar. The first dimension is institutional. So Mishpat is in a way an institutional administration of justice. We can use justice, of course, when referring to the job of a judge. Justice is the process, but also is the result, the sentence, on which basis the judge determines, as Raz would say, legal rights and duties of the parts in the case. We can take this as a first approximation to Mishpat. This perfectly explains many translations, judgment, but also law, decrees, etc. Even without a unique translation, I think it is clear that the meaning is in some way institutional. An example will help, and this is the first quote in the screen. When they have announced to you the verdict, in this case, you shall carry out the verdict that is announced to you. You must not deviate from the verdict that they announce to you, either to the right or to the left. What is interesting here? That in ancient Hebrew, we have 2 words. Mishpat is the first, but the second is davar, but the translator used verdict both for mishpat and for davar. Another translation is very different. This second translation tries to combine the 2 concepts, mishpat and davar. Davar has a linguistic element, can be translated as word utterance. So a second translation, instead of the verdict, use the word of judgment. So insisting on the fact that the judgment is a normative formulation in according to our tradition. Well, the diversity of translations can be considered as a source of misunderstanding. But on the contrary, it sheds light on the first point I want to highlight. Using our contemporary theoretical categories, we can say that mishpat has a formalistic connotation. It does not matter if it translates it by justice, verdict, decree. What is central is the formalism of this notion in 2 important senses. The first is that the judgment comes after a proceeding governed by rules. Its formalism is firstly the formalism of the process, whose combination is a verdict, a sentence. But formalism is also at play when executing the verdict. The use of davar helps to understand that whatever the verdict is, people should comply with it in a literal way. No room for a flexible interpretation or some implicit meaning. The judgment is such as it has been formulated. The value at play, retaking a famous debate about rules and models of decision-making, shower, for instance, is without doubt legal security or legal certainty. A formalistic application of legal rules is central in the Deuteronomic legal philosophy. The value of legal certainties is often related to the existence of written law, a text expressing rules. Judges should apply those rules, even if eventually they think rules can produce some kind of injustice or any kind of bad consequences. The use of davar that is a reference to the linguistic formulation, is key to understand this formalist aspect. Despite this formalistic aspect, there is a strong connection also with the common law tradition, given that the term mishpat is also used in some occasion to refer to customs. The second quote, maybe, can we just, the second quote from Esdras is an occasion in which mishpat is translated by custom. They kept also the Feast of Tabernacle as it is written, and offered the daily burnt offering by number, according to the custom, as the duty of every day required. So even if mishpat has a formalistic connotation, it also serves to refer to custom, so to the paradigmatic source of law in a non-written tradition. By the way, another translation of the same Esdras 3:4 completely ignore the distinction between written law and custom. They use in both circumstances as prescribed. So they completely ignore the difference between written and custom, written and unwritten, and they translate both by the meaning of the source as prescribed. So the only thing important is the prescription, no matter if the prescription is from a written sources or from custom. Well, I think the concept of mishpat captures in all the complexity of the judicial activities. Formalism is not incompatible with discretion. This point maybe needs some explanation. What is formal is the proceeding. The procedural rules are there in order to avoid any sort of arbitrariness. Then, once formulated the verdict, formalism is at play in order to ensure that the strict execution of the judgment. But as the sources judges have to apply are not French legislative sources, I mean a very example of continental formal sources, there is not place for this kind of textual limitation. If what is applied in a formalistic way is some kind of custom, there is a lot of room for discretion, even in a procedure that is completely formalistic. What I mean is that we have not, as Jose Juan said, we have not two floors, principle very ambiguous and rules very clearly formulated. We have prescriptions, and prescriptions are administered by judges. And it is not very important if the prescription is a very general rule, or if the prescription is a very specific rule as about food, for example, a prohibition about food. We can't eliminate the role of judges interpreting sources. And actually what we know as written sources, the Pentateuch, are oral traditions written much time after they were played, they were applied, etc. Well, in order to introduce the second notion, we have to just reconstruct, using the King's two quotes, a list of sources that is very often formulated in many distinct verses of the Old Testament. So I just quote, they do not follow the laws and practices, the teaching and instruction. Laws, practices, teaching, instruction. We have 4 words, and each word corresponds to a very, very singular concept. Laws are chukim. Chukim is a very interesting concept. Usually we consider that as written statutes, but the very idea in this concept is that they are rules without any obvious justification. So we have to comply just because they ordered the rules. So in a shower language, they have not a subjective justification. It is just the rules, and it is because the rule is valid that we have to comply. The practice is mishpat. Mishpat is custom. So it is a rule, but we all know why, because we have this rule, because it's social. It is a social rule. Chukim is just a rule. Mishpat is rules, but customary rules. So rules that are completely inscribed in social practices, eventually social values, etc. Institutional morality play a big role in this. The teaching is the Torah. The Torah is the Hebrew words for the Bible, and the Torah is the legal system. It's the whole set of legal sources. The Torah is not a rule. So we can refer to laws as just legal rules without justification, practices as customary practices with a social justification, and we have to comply in general with the whole legal system. And finally, we have instruction. Well, instruction is a translation, obviously questionable translation, of the very famous word mitzvah. No? We all know the bar mitzvah of some friends. Well, mitzvah means rules, but it is a rule considered as inscribed in a charity activities. So the idea is that all the mitzvahs are theological oriented to charity, to justice in the sense of doing charity, some deeds of charities. Well, what is interesting here is that mitzvah open to the tzedek dimension of justice, because tzedek is often translated by justice, but in many, many occasions by charity. And actually tzedek was transformed in Christian tradition, and Christian charity came from Jewish tzedek. But what is the role of tzedek in a judicial context? Well, the federal judge I mentioned in the beginning say the following, I quote, in Deuteronomy, Moses tells the people that when they enter the land, they had to appoint judges and officials for the tribes in all the settlement that your God is giving you, and they shall govern with mishpat tzedek. There is the combination of the two concepts, and very often this mishpat tzedek is translated as due justice or eventually just judgment. So if the judgment is just because there is a system of justice, we have court proceeding, etc., what is the addition of just justice or just judgment? What is the addition in a context, in a judicial context of tzedek? Well, I think we have a very clear example of flexibility. So in the first part, we have seen that mishpat has a very strong formalistic dimension. So we have to apply strictly the rule. But what if the application of the rule produce a very unjust outcome, for example? And in particular way, when the vulnerable, the poor, the stranger, the fatherless, the widows is in court. So tzedek is a way of flexibility, is a way of making flexible the application of formal rule. But it is not, I can phrase that asking if God is an inclusive legal positivist, but not, because tzedek is not a value as such, is not dignity, is not liberty, is not whatever value we can think the text is incorporating. No, it's just a way to say to judges, okay, your role is to ensure security, legal certainty. because of this, you have a very important role. But this formalism, this legal certainty cannot be a tool or just a way to produce social injustice. So tzedek is a way of introducing a charitable interpretation when we have discretion, and we always have discretion. So it is not just a value incorporated, it's just a duty for judges in order to always interpret, taking into account the more vulnerable people. So we can have migrants, fatherless, etc. Tzedek is in some way a light in order to orient judicial discretion. But we have just judicial discretion. We have not a set of universal and eternal values that are incorporated once forever in the legal system. We have just judges, competent judges, that have a very strong discretionary power, but they have ordered by God to use this power, taking into account not only the formal rule, but also substantive justice. Not a value in particular, but some social sensibility, I would call this. Well, just for finishing, a very famous commentator of the Old Testament, Rashi, when interpreting the imperative of pursuing justice, tzedek, provides this interpretation. Pursuing justice, tzedek, means go to a reliable court. Thank you very much.
Thank you, welcome.
Thank you very much for these insights in the Old Testament that we not get so much from a legal perspective normally. You were in the beginning saying that your hypothesis is that it's very close to positivism and realism in some sense, and I see the connection to art immediately, of course, with some formal description and the opening to discretion. But is it not so? When I then was hearing what you're saying, is it not so that this is open? It could also be a parallel to Aristotle. I mean, Aristotle also has the idea of corrective and distributive justice, and then equity, which goes into the individual cases if they are not compliant with the formal legal certainty idea. And there you are definitely not in a positivistic system, but in a system which applies natural law content to that. So, is that a contentation of your thesis or not?
Well, I think the difference is very clear. In the case of any Greek philosopher, the source is nature, our human nature that help us to follow the middle way or the just solution. In that case, we have no reference to nature. We have just references to legal sources, to texts. There is no room for nature. Obviously, it can be transcendent because God is part of the picture, but we talk about the feasibility today, and there is a rabbinic doctrine that says that the God's will can be defeated by the majority of judges. So we have really a set of texts and very strong courts. And God is there in a Chalcedonian way just to offer the first ground of legal validity. But God is not in courts. God is in heaven, judges human being.
The Grundnorm, I would say.
Exactly. But the first point is that nature is not invited.
Yeah, this is great. My name is Gonzalo, professor of law from the University of Chicago. I teach religion and legal systems in Middle East and North Africa also. So this is fantastic. I'm surprised that I jumped in this group to hear this at the end. Just, I think when you talk about Jewish law generally, it's very important to know that we have parallel two legal systems that in one package, rabbinical law and biblical law at the same time. And fantastic, this is fantastic. Actually, what Professor just said, he mentioned margin of appreciation and using, of course, and this just comes to the picture completely perfectly now for me. You know that there is the biblical law as a primary source of law, which actually cannot be changed in a way that it's eternal, it belongs to God, and it is as it is. But we have a rabbinical law at the same time, just developing parallel to this. The perfect example of this would be, you know, in Jewish law you have this dinam utadina principle, which basically means, for those who know a little bit of the basics of Jewish law, you should follow the law of the land. So just example, very interesting, which also my mind just now, that, you know, Rabbi Ben Gershom in Germany, in Mainz, decided it was a question of polygamy. So he decided, because Jews in that area were surrounded by Christians, that just to follow the principle, to follow the law of the land where they live, so that they should have only one wife. So many Jews came to this guy and said, come on, you know, we don't want that. You know, there are sources in the Bible which allows us to have more than one wife. Oh well, I'm not changing biblical law. You know, if you find 100 rabbis, you still can have 2 or 3 women. But you know, at that point, there were no 100 rabbis anywhere in Europe. You could do it even if you want. At the same time, if you see North Africa, Sephardim Jews, who are surrounded by Muslims, they kept this polygamy for much longer than Ashkenazi Jews in the East. So, and of course, what you said, margin of appreciation. Of course, that's exactly that. The courts, particular courts, are using their own circumstances just to divert the law. They are not changing the law; they are just diverting it and making applicable to particular situations. So, thank you. This was just a comment. I enjoyed. Thank you so much.
Thank you. Actually, just one little comment. We also know that the question of gender is very important. So, rabbinic tribunals in the world are interpreting marital law according to the gender perspective. It is not in the text, obviously, but the role is to adapt the text to the evolution of societies. And societies, yes, whichever the society, distinct interpretations.
Thank you. Thank you. Very interesting presentation. The question is to test your, is there the right of resistance in case the court's decision it reaches the unjust? What's the solution that because that's the point in order to demonstrate whether they actually are positively or not. And the other thing is that I don't know. I'm just asking out of curiosity. And I don't know if the theological presuppositions of modernity. Did you know? Straussians devote a lot of attention to the find theological origins in every single modern point.
Well, the first point, I don't know. Actually, I will try a short answer, a little bit comic. If you don't agree with the ruling, you change the court. So eventually, you have the liberal rabbi, the Orthodox rabbi. So depending the decision you are waiting for, you can choose your interpreter. But I'm not speaking about Israel, of course. I'm speaking about Jewish law applying in a context without a state. So of course, if you have a state with force and with structures able to oblige people to comply, well, it's different. The second point, thank you very much for the question, because it's very usual to have people playing to Carl Schmitt and political or legal theology. My perspective is completely the opposite. I propose a legal reading of divine sources. I am not proposing a theology. I just taking the Old Testament as we can take in, for example, the Federalists, Constitutionalists, systematically quoted Hamilton, Jefferson. Why? Why? We have no reason. They are not Italian, they are not German, they are not Catalan. Why? So the point is, if people have no shame quoting US political philosopher and constitutional designer, why we can do the same with the Old Testament? Why we can use Aristotle, Plato, etc. Exactly. So it is just, okay, we have sources. We have legal, written, very old, and not universal, but very known. And we have a lot of learning available, and just for, a sort of secular prejudgment, we avoid to use some sources. Aristotle is okay. I don't know why. No. All the social, moral problems Aristotle had would give us very strong reason to avoid. And on the other hand, just because in Europe at least we have developed this very strong anti-clerical secular laicite, well, we live a life without, not without God, this is a personal thing, but without some legal sources that are plenty of very interesting normative conflicts, doctrine about interpretation, discourses about constituent power. The election of Israel is an essay about constituent power.
On the part of the Constitution, why is it reasonable for them to quote medicine no offense, the rest do you want me to answer that? Well, because as every legal phenomenon, constitutional law cannot be understood outside of the common understandings of it. Historically, for common understanding. So when we are applying constitutional law, we must be aware that we are applying a constitutional law in our realm, cultural realm. So we always have to make an effort to reconstruct that in order to reconstruct the common understandings of historically informed, of course, understandings of law.
I understand the point. It is a mistake, but I understand the point, because actually it is a Puritan tradition. So why Puritan and not Catholic or Jewish or Muslim? So it is not universal, it's just dominant.
That's a different question, because that's the methodological point of how to reconstruct the common understandings. And then there's Barber, there's thesis, there's a lot of discussion around that. But that would be an easy answer to your question.
Okay, so for a long conversation after that.
Thank you for the presentation. It was really, really interesting. And I have a really general question about maybe your aim, or I don't know if say underlying your thesis. Do you want to do a historical reconstruction for a better understanding of this big law, or are you thinking also in something to defend the possibilities, or maybe maybe rethinking some thesis of the natural law?
Okay, well, there is not a short answer, but I will try because the coffee. Well, my aim is not theological. My aim is fighting against naturalism, but not with the usual guns. So you can't, from Genoa, from a very realist, skeptical school, to criticize people having some social, moral compromise. So my idea is to use the oldest source of religious dimension to criticize any form of natural law, any form of, precisely, any form of deriving what we have to do, our duties, from nature. And the other aim, and this is another paper, is try to provide an interpretation of Kelsen, basic norm, from the Old Testament. I mean, God is at play in Kelsen, but a very distant God, a God that is just an idea, the ideal nature of legal norms in Kelsen. It is because there is something no human by definition. No? Because of the regressum ad infinitum cannot go to the natural first constituent. So we have, or maybe it is the same aim, because Kelsen is positivist, and I think that to save positivism, we have not to incorporate moral, we have to look for stronger transcendent reason to be exclusive positivist. Well, we have to introduce some problematic ideas as God, but if God is not nature, if God is not human, as in the Christian tradition, if God is just norm, we have just Kelsen. There is nothing different from a first norm. And a first norm that is just a tool in order to give some ground to judicial discretion. It's not because I'm telling this, it is because God outrights me when, I don't know, someday in the past. Thank you very much.
I have a question for my partner, that is, well, that practical interpretation, legal interpretation, or theological interpretation, there are certain persistent problems. For instance, in an interesting book combining these traditions, I read a lot of time ago, of some Levinson, American constitutionalist. Some Levinson said, there, for instance, inside the Christian tradition, there is the interpretation of Bible, there is one aspect of difference between Catholics and Reformers, of Protestants, of the Reform, partiaries of the Reform, that's in the Reform defending the interpretation that is only the Scriptura sola, not the Scriptura sola, only the Scriptura, and Catholics said the Scriptura tradition. This is very similar to the distinction between, I don't know, originalism and living during constitutionalism. In fact, this is persistent. But there is another different age dividing Catholics and Reformers. That's the question of, for Catholics, there is the infallibility of Papa. The last word is in one person and one way. And for reformists, there is free examination. This is liberal examen. This is the idea. And this makes four possibilities. No? I am more, but I confess, I am more particular of living free, and and liberal exam. But other, and I think I read sometimes that these questions are present even in the rabbinic tradition and in the interpretation of Old Testament, in the rabbinic tradition and the Talmud tradition. I am totally ignorant, but I read that. But my point is not in which sense this is present in the tradition. My question is, well, perhaps more than one positivistic point of view or something like that, this tradition shows that there are certain tensions and divisions in all exercise of interpretation of so much relevant in a culture, in a society, and so on. And perhaps it's universal. And certain aspects of the dispute between natural law and legal positivism is the consequence of this tension present in this tradition. That's just
Well, I just one word because I just take the suggestion of studying and using what you say. But I think the first point, there is a very deep bridge between the Jewish tradition and the Protestant traditions. Because of that, many assimilated Jewish in Germany was thinking that German humanism, Kant, for instance, was a philosophical way of retaking the prophetic messianic message. Well, they was wrong, but this is another history. And the very difference is that in Judaism or in Protestantism, you have not the strong institutional church, the state with universal truths, the dogmatic church. So this is in a way a common enemy for Protestant and Jewish. And the other, of course, if you analyze the evolution, not of religions, but of legal philosophy, we have a monster. This monster is Thomism. Because when God's will meets the common good, it is a religious, dogmatic, and naturalist monster. Actually, the fight of positivism was the fight against Thomism. So I think we have, my idea is, okay, we can't reduce religion to Thomism. The religious dimension is much more rich and open to a philosophy that is not finished Thomism. We have a religion presence in other legal philosophies on the side of positivism. I think Judaism is there to fight with positivism against Thomism, because positivism alone is fragile, because it's just fact eventually. We need some more. We need some transcendent dimension. Kelsen has this dimension. Hart has not. But it is a way of equilibrate the legal philosophical panorama, because the other side is too much strong.
Thank you. Thank you very much. Thank you, Roberto. Thank you. This is the final session. Just 1 minute. Thank you for contributing to this workshop. Thank you very much for your interventions. Thank you at all. And thank you, especially thank you, particularly thank you to Gonzalo, because Gonzalo organized that fight on the name and the chair, but fight Gonzalo organized that, organized the and after the informatic system and the camera and Gonzalo is really a very generous scholar, and I am very grateful, and I am asking you an applause. Thank you.